Good morning, everybody, and welcome to our talk, a further talk in the Litigation Lessons series with myself and Ali Claffey.
Hi, good morning.
This morning's talk is on directors' duties, explained, understand, and prevent breaches. Now, I'll do what I always do, really, and deal with housekeeping matters at the start. Thank you all for coming. Firstly, we're grateful that you give up your time to us for this event. We're going to try and keep it to 1 hour because we know you're all busy. But as always, that means that we've got a lot to cover in that hour. So if you have questions, please email them to us afterwards, and we will then revert to you. And I'm conscious as well that not everybody wants to ask the question, as it were, in public if they have a dispute or similar. So just to say that. A disclaimer, this is obviously a high-level overview. We'll try and give you as much detail as we can, but obviously we won't be able to cover everything, so it's not legal advice. And law does change, as it were, so it's accurate, as it were, at the time that we go ahead, but it's very much an overview. So again, please get in touch if there's anything that's more serious or specific. We will email you out the slides afterward. We'll also let you have a frequently asked questions sheet, and then there'll be an opinion piece just on directors' duties and sort of, the modern state of them, as it were, from me, sort of a little later on. I always say this, and I don't want to sound like a broken record, but Pretty's is a learning organisation. We take your feedback very seriously, and we always look at any suggestions or suggested talks that you put in the feedback form. So please do complete the feedback. If there's anything that you like, let us know. If there's anything that you particularly dislike, let us know. Hopefully there won't be anything that's strong, but let us have your thoughts. And then at the end of this talk, there will be our contact details. I think most of you know us, but those will show up at the very end. So to begin, as it were, at the beginning and give a little bit of context to directors' duties. Now, the majority of the duties we're going to talk about today, and I'm giving this sort of before we get into it, are what are called fiduciary duties. Now, fiduciary duty is really one of the highest standards that the law has to hold, as it were, an individual to. If you look up sort of fiduciary duty in a legal dictionary, the words that sort of frequently come up are undivided loyalty and best interests. And so it's a very high standard. It's the standard that a solicitor owes to their client. It's the standard that a trustee or an executor owes to their beneficiaries. And as I say, it's the standard that directors owe to their companies. And so while there are obviously a lot of directors that are all doing great directors' jobs and directors' businesses every day, it's important just to realize that this is a serious standard, which hopefully none of you will ever fall foul of, but it is in law one of those sort of things that's frequently sort of overlooked. If you look at a solicitor, you expect him to act to a high standard. Directors sometimes see it just as part of operating a business. So my point is, it perhaps, well, I say perhaps, it needs really to be given more consideration in sort of day-to-day operations. Now, as you probably worked out, fiduciary duty tends to come in and operate in what we in the law call agency situations, where you have a principal and you have an agent, with the agent acting on behalf of the principal. So again, solicitor, client is seen as a principal agent sort of situation, trustee, beneficiary too, and directors and companies. So it's really where, as it were, one individual is putting responsibility or their life in the hands of the other individual, albeit in a business context. And so that's why the fiduciary duty has grown to fill the director company role, because clearly the director has the responsibility of the company, the employees, the creditors, the shareholders, in terms of the day-to-day dealing. Now, one of the byproducts of fiduciary duty is that if an agent makes a profit, as it were, they have a duty to account for it unless it's disclosed or agreed. So when I'm dealing with a claim, often, for example, if I'm dealing with, say, a non-fiduciary situation, I'm often looking at just claiming for the loss that my client has incurred at the hands of, say, a plumber, an engineer, or whatever. But when I know there's a fiduciary duty, if I'm going after a solicitor or a trustee, I know that I've got more purchase because I can actually go after them for any profit that they have made or any loss has been incurred. They have to account for it. So again, just a higher standard and almost an easier target, which is why it's important to be, strict. So really, going back to undivided loyalty and best interest, the sort of flip side of that is you have to put yourself as a fiduciary in a position of no conflict and no profit. Now, fiduciary duty applies to the majority of the duties we're going to run through today. It doesn't apply to some, for example, exercising reasonable care and skill. That's on a fiduciary duty. It's more of a sort of a practical one, but it does the remainder. In law, and these are the most common words that we see in any case, the words with hindsight. So obviously when it goes wrong, it's always been picked over by the judge, 6 months, a year, even, 5 years after it's taken place. So where you have hindsight, the point is you need foresight. And one of the themes that's going to be running through today is really the creation of evidence. You need to be able to demonstrate that the conduct that you give, the actions you take are properly thought through within this fiduciary scenario. So without further ado, I'll hand you over to Ellie.
Thanks, Brian. So now I don't want to teach anyone to suck eggs here, but the key roles of a director and a shareholder in a company are often confused. And so I think to start, it is worth just quickly setting out the difference in those roles. So starting with a director, directors are responsible for the running and the managing of the company. So they set out the business strategy and they make day-to-day operational decisions. Now, importantly, directors owe legal duties to the company, which we will come on to more shortly. Now, if they breach these duties, they can face personal liability, which makes their role both powerful and accountable. Now, in contrast to that, shareholders are the owners of a company. They invest by buying their shares, but they do not take part in the day-to-day management of the business. Instead, their influence is exercised through things such as their voting rights, for example, by appointing or removing the directors or approving of major decisions. So their financial risk is typically limited to what they have invested. Now, what's important to remember is that they are distinct legal roles. So even though in practice, particularly in smaller companies, one individual can be both a director and a shareholder, when wearing each hat, they are subject to different rights and responsibilities. So in summary, directors run the company and shareholders own it.
Thank you. So we've looked at sort of the overview. Let's get into sort of the legal framework by which, as it were, directors will be judged. Now, these broadly fall into two main categories with a little bit of a theme running around contractual and constitutional, but I'll begin sort of with the main duties. Now, these are codified in the Companies Act 2006 and are contained in sections 171 to 177. I won't run through them all. They're listed here and we're going to go into them in more detail as we run through. But broadly, these are called the general duties by lawyers. These are sort of the bread and butter ones. And again, as I say, they're set out there. They're owed broadly by the director to the company as a whole rather than to individual shareholders or individual creditors. It's sort of a having, as it were, a view to look after the company and then all its sort of incumbents that form it, rather than looking after one or two groups or an individual. A breach, and again, we'll come on to this, can lead to personal liability, director disqualification, or other sanctions such as contracts that have been entered into being set aside. Now, the common law, the statutes set out the basics of what's required, but law is obviously a living thing and the statutes can't deal with everything. So we have the common law, which is really the cases that go before the judges that qualify what the codified parts under the Act mean. So, for example, example, promote the success of the company, there will be hundreds of situations where a director thinks that he has promoted and perhaps the liquidator thinks that he hasn't, and the court will decide that, and that then leads to a body of case law. So it's primarily statutory, but it is coloured by the common law. And then to go back just to the theme that I mentioned around the contractual and the constitutional, some companies, obviously not all, but some companies will have clauses, terms in their articles of association, which will state, as it were, how the company is to be run, and the court will take those into account. So, say for example, I mean, again, I don't know that there is a duty that every decision must be, for example, green or ecological or something. If there is a decision that clearly isn't, then that may, as it were, play a part in the legal framework as a whole. Now, I put down here shareholder agreements. Now, we do not have a case that actually deals with a scenario where there is an agreement between shareholders and by which a director was effectively sort of hoisted before the court for not complying with that agreement. But there is a lot of dicta by the judges in a lot of the cases that effectively says that where you're dealing with a small company, effectively what we call a quasi-partnership, perhaps two people who've gone into business together and then incorporated in order to get limited liability, that if there is a shareholder agreement between the two that sets out how the company is to be run, in that smaller situation, what the shareholders agree may play a part. I mentioned it just for completeness, but again, we've had no live case that deals specifically with it, but we have had a number of judges that have basically mentioned it. So that's that. Back to you, Ellie.
Thank you. So just in case we haven't made it clear, directors' duties are owed to the company itself as a separate legal entity. Now, that is a fundamental legal principle. So once a company is incorporated, it is its own person in law. It is distinct from its shareholders, directors, or employees. So when directors make decisions, the question always has to be, what is in the best interests of the company, not a particular individual who is connected to it. So, for example, if a director is also a shareholder, they cannot prioritise their own dividend income over what is best for the company's long-term success. Further, if a director was appointed by a particular investor, they cannot simply follow that investor's instructions if they think that doing so is going to harm the company in any way. So understanding who directors do not owe duties to is also just as important as understanding who they do owe their duties to. So directors do not owe duties to individual shareholders, even if that shareholder holds a majority stake or is appointed the director to the board. So if we take an example, a venture capital investor appoints a director to the board and asks them to push for a quick sale of the company to release a return. Now, if that sale would undervalue the company or damage its long-term prospects, that director must refuse because their duty is to the company, not to the investor who appointed them. Now, in the ordinary course of business, directors do not owe any duties to creditors. However, this does shift if the company is approaching insolvency. So Graham is going to touch on this shortly, so I won't go into any detail now. Directors also do not owe any legal duties directly to employees, customers, or suppliers. Now, with that said, under the UK law, specifically Section 172 of the Companies Act, directors must have regard to these stakeholders as part of promoting the success of the company. And I'm going to come on to this a little bit more later. So, for example, if keeping a factory open would seriously damage the company's financial position, the director must ultimately prioritise the company's interests, even if the employees are adversely affected. So bringing it all together, directors sit in a position of trust, but their loyalty runs with the company to act as an independent legal entity. It's not the individuals around it. Thanks, Graham.
Thank you. So I'm going to deal with this here because it's one of those duties which sort of isn't what you would call necessarily your first thought when you think of directors' duties, but at the same time it is sort of an important one. And although it has a little bit of, it is mentioned in the Codified Companies Act, it has sort of its roots in as we said, the common law and in case law. So basically, as Ali has said, primarily in running through, there are the duties are owed to the company in the first instance, and as we'll come on to in regard to promoting the company, there are factors which must be taken into account. But there is a specific circumstance where, if the company is, as it were, in a financially precarious position, or there is one on the horizon, or it's looking very likely, the duty shifts from, as it were, employees, shareholders, companies, and it begins to focus on creditors alone. So as I say here, there is what's called the creditor duty, as it's abbreviated to, arises when a company is insolvent or bordering on insolvency, or insolvency is kind of like a factor or a probable outcome. It's broadly codified in section 1723 of the Companies Act, where it basically says there's a duty to promote the success of the company, but this particular section says those duties under English law, as it were, may change to focus on the creditor. So what changes? The director must give priority to creditors' interests, shareholders' interests become secondary, and obviously that focus is something where if a company's gone into insolvency, the liquidator is going to be looking at, if you sort of go back to my hindsight argument, it's going to be one of those where it needs to be shown that there has been this sort of sea change from running the company to perhaps being more defensive and prioritizing creditors' interests. Practical sort of consequences, I'd avoid really, which again is common sense, but avoid situations that lead to the company's position worsening. A liquidator looking at a company that's been, it's has been wound up, gone into liquidation, will be looking at, who were payments made to, were they made preferentially to some creditors rather than others, was there more borrowing, have assets been disposed of that shouldn't have been, has the company continued to trade beyond a point where it should have been. And these really tie in more with sort of the wrongful trading and fraudulent trading rules that are in place anyway, in that you're not supposed to continue entering into contracts with creditors if you know there's no way that your company's going to be likely to fulfill those contracts or trade out. So there's potential personal liability for breach of this in terms of wrongful trading. You can lead to directors' disqualification, but we'll come on to broadly the likely remedies that they face later on, and there'll be claims for misfeasance by a liquidator or administrator. So the point is, the closer the company comes to an insolvent event, the higher that duty ramps up, if you're following me. So this originally came out of case law. West Mercia was the original one where the judge talks a great deal around this, but the key case is Sequana, where effectively the court really did go into detail around this, and effectively, as it says, the Supreme Court confirmed that directors must consider creditors' interests when the company is insolvent or on the verge of insolvency, or when insolvency is probable. Duty is not binary; it intensifies as the distress increases. And once insolvent, as it were, it's inevitable the creditor's interests prevail. So I say this now really just so you sort of, it gets it out the way, and everything else will follow and be more fluid in terms of they're more common duties owed to the company. And this is obviously quite special and applies to a specific situation. But hopefully you've got that. Just make sure, as I say, that you're aware that if you're starting to see changes, that you factor that into your decision making. Back to Ellie.
Thank you. Okay, so here we are going to look at the first of one of the core duties under the Companies Act 2006. This is the duty to act within powers as set out in section 171. So in simple terms, this duty has two key elements. First, directors must act in accordance with the company's constitution. Now, particularly its articles of association. That means that the articles aren't just guidance, they are legally binding, and directors must stay within them. Second, directors must exercise their powers only for a proper purpose for which those powers were given. So even if a director technically has the powers to do something, they must only use those powers for the right reason. So if we turn to an example, under the Model Articles of Association, directors have the power to issue shares. However, that power must be used properly. So, for example, if directors issue new shares simply to raise capital for the company, then this is likely to be for the proper purpose. But if they issue shares for the purpose of diluting an existing shareholder's voting power or to maintain their own control of the board, that would be an improper use of that power, even though the articles technically allow a director to issue those shares. So if this duty is breached, the consequences can be serious. The decision itself can be set aside. Directors may face personal liability, even where they honestly believe they were doing the right thing. And that leads to the key message. Good intentions are not always enough. Acting in what a director believes is the company's best interest will not protect them if they have acted outside their authority or for an improper purpose.
Thank you, Ellie. So section 172, duty to promote the success of the company. Now, broadly, core duty here, director must act in good faith. We've talked a little bit about fiduciary duties previously, but must act in good faith in a way that honestly consider most likely to promote the company's success and act for the benefit of the members of the company as a whole. Now, you often see this scenario really where you have almost an old co and a new co. You have a director who is a director of both companies. The old company perhaps isn't doing so well, or has debts, or perhaps has a claim against it. So a new co is set up, and the director then looks to, as it were, divert the business away from one company to another company. And it's usually situations, it might not be a new co, it might be they're running two successful companies and there's some overlap. But normally, as I say, this would be a hindsight position that a liquidator would be looking at to see when the company is dead, why it died. And so again, it sounds like everybody will want to promote the company, but it's almost again back to this fiduciary duty of plugging holes in sort of acting in with the utmost good faith. Factors that the directors must have in mind are the long-term consequences. So again, if it looks like it was kind of bet the farm and a short-term risk, that could, as it were, be something that the court doesn't like the look of. It's supposed to have regard to the employees. So again, it's not just the shareholders, it's sort of the long-term viability of the company. You know, it's the employees. Relationships with suppliers, they call, as Ellie said, they're called suppliers in the Act, as it were, but we've got this creditor duty, and your suppliers, you know, potentially your creditors, and your customers, again, who are potentially likely to be, you know, creditors in some way too. Community and environmental impact. We talked a little bit more about, you know, provisions in articles which say that things have to be dealt with, you know, in a more eco-friendly way. It'll look at whether the action damages the reputation, the standards of the business, and really whether it's a fair decision. You know, were some shareholders given preference, as it were? And this goes back to really what Ellie was saying at the start. In a lot of small businesses, the shareholders and the directors are the same people. So again, yeah, it's a bigger picture than just sort of, as it were, being the owner of the company. So this, again, key points to take away. This is really a decision-making duty. The court's not looking necessarily to judge you on the outcome, but it is looking to make sure that when you make the decision, that all of the above was properly, you know, taken into account, and there was proper consideration paid to it. The directors, as I've said here, must show they turned their minds to these factors. And as I've said, the creditor duty is obviously potentially there as well. We mentioned about it being part of section 1723. The promotion of the company does include potentially looking after creditors, albeit, as I've said, that becomes much more acute in an insolvency situation. Ellie.
Thank you. So turning to section 173. Now this is the duty to exercise independent judgment. So at its core, this means that each director must make their own decisions. They cannot simply just follow instructions or defer automatically to others. So in particular, directors must not blindly follow shareholders, even majority shareholders, a parent company in a group structure, or any other appointing body. Now, the key point is that once a director is appointed, they are no longer a delegate. they are required to apply their own mind to the decision in front of them. Now, that doesn't mean that directors have to operate in isolation. For example, directors are perfectly justified to take professional advice, such as legal or financial input, act in accordance with the lawful agreements, such as the shareholders agreement, and they can still delegate tasks, provided that they continue to supervise. Because whilst you can delegate tasks, you cannot delegate your responsibility. So there are some common areas where this duty does become particularly relevant. So, for example, in situations where you may have nominee directors who feel a loyalty to the person who appointed to them, or group companies where there may be pressure being placed upon a director to act in a parent's interests. And decisions involving a dominant founders or majority shareholders whose influence can be hard to resist. So the key message is simple but important. Every director must be thinking for themselves. So even where there is pressure, their influence or expectation from others, the director must still make an independent judgment in the interest of the company. So listen to others, take as much advice as you like, but ultimately the decision must be your own.
Thanks, Ellie. So Section 174 of the Companies Act, excuse me, to exercise reasonable care, skill and diligence. So I've said this isn't a fiduciary duty, but this is still a relatively high standard. So broadly, this is a two-stage test. The first stage is an objective test, and the second stage is a subjective test. And the first test is whether the action that you've had to demonstrate care, skill and diligence over would be one that a reasonably diligent person in that role would have made. So that's not, as it were, that is just the standard. A court will look at it and think, would a reasonable person, to use that well-trodden law phrase, on the Clapham omnibus, have acted diligently faced with all of the factors? And the judge will assess that. And really, that is the minimum standard, as it were, that the court is looking to hold you to. Would a reasonably diligent person have acted in the way that you did? As I say, it's not necessarily looking at the outcome, albeit that will clearly play a part in it, but it's looking really at the process. We keep saying that, but it's the process, demonstrating the process has been met. Having met that, obviously, if you don't, you fall at the first hurdle, but having met that, the court will then look at the directors. This is a subjective test. Will then look at the personal position of that individual director, their actual knowledge, skill, and experience. And so I suppose the point is that if you are dealing with, a high-level finance director who's been an accountant for many years, run firms like this for many years, the standard on that individual may be deemed to be slightly higher than, as we've said, the man on the Clapham omnibus. And again, it's not really looking at the business decisions, it's more the experience and recording that the thought process was there. But if you have that skill, potentially you are going to be held to a higher standard. So you almost have the minimum, as it were, and then potentially, depending on your experience, you have a maximum. And so hopefully, most people will fall somewhere in the middle and can demonstrate what's happened. But it is the combination of the two that the court will look at. And as we say, there are higher expectations on those with more skill. This really then plays in, I suppose, just because this is perhaps one of the harder ones to try and demonstrate. This really boils down to keeping and creating good evidence, stay properly informed, attend board meetings, make sure those meetings are minuted. You are really looking, as I keep saying, for a situation where, with hindsight, if you are challenged on it, you can point to what the factors are. It's around the process. Inexperience is not an excuse, but expertise, ironically, as I say, there does raise the bar. It's not a fiduciary duty. And then just one final point. Often directors will delegate matters that sort of are more around reasonable care and skill than perhaps being central to running the business. Obviously, delegation does not let you off the hook. You are still responsible for what your employees do and actions that they take and which have been authorized by you. You might have more success deflecting liability if you instruct a lawyer or an accountant, or you take professional advice, but in terms of sort of day to day, that buck still stops with you. And even with a lawyer, it would still be down to you to follow that advice or or qualify it or whatever you needed to do. So please, again, bear that in mind. Over to you, Ellie.
Thank you. So the duty to avoid conflicts of interest. Now, this is one of the strictest duties imposed upon directors. So what is a conflict? Well, a conflict arises where a director's personal interests conflict with the interests of the company. Importantly, this is wide-ranging. It doesn't just cover actual conflicts, but also possible or perceived conflicts. So this may include situations involving personal business interests or corporate opportunities that really do belong to the company, or other directorships, particularly where businesses may overlap. So the key requirement is strict. Conflicts must be avoided, not just disclosed. However, in some cases, a conflict can be permitted, but only if it has first been properly authorised by the board, and only where the company's articles allow for that process to happen. So in practice, this means directors need to be very alert to any potential conflict and deal with them proactively. So this may be more common in areas such as group structures, where a director may sit on multiple boards, competing ventures, for example, where a director has an interest in a rival business, or perhaps they have some form of a side hustle, and the exploitation of business opportunities. For example, taking an opportunity personally, even though the company could have pursued it. So the courts do take a particularly strict approach here. Even if the company does suffer no loss or the director acted in good faith, there could still be found to be in breach. So overall, if in doubt as to whether there is a conflict, declare it early and seek board approval. The safest approach for directors is going to be transparency. So identify potential conflicts upfront, ensure that they are properly authorised before taking any further steps. Thank you, Graham.
Thank you. So section 176, coming to the end now, hopefully, not to accept benefits from third parties. Now this, going back to my comments about fiduciary duties, this is fairly sort of obvious. What's prohibited? Directors must not accept benefits from third parties conferred because they are a director. So in other words, those that come, as it were, the director's way because he is a director. It applies in all situations. I talked about this need to account for sort of, as it were, secret profits or profits. Even if, as it were, the payment or whatever it is, tickets to Taylor Swift, even if none of that is taken into account as part of the decision-making process and potentially has been documented, it can still be used as being sort of an influence or something which the director can be held accountable for and which he has to account for. There's no need for dishonesty or any real intention here. It is more just an obvious objective fact. So examples, I mean, again, I mentioned some, but gifts, inducements or hospitality, giving work experience to, another business's sort of, the director's daughter or something. All of these things come into play. Commissions, referral fees, any favors linked to your position, you have to be careful of. So obviously, if that is, if this is something, declare it at board meetings, tell your other directors, make sure there's a record of it. But again, I suppose primarily don't put yourself in a situation where there is going to be any question around your receiving whatever that benefit would be. Now, there are obviously exceptions to this, the benefits that cannot reasonably be regarded as having given rise to a conflict. So, obviously, if your mum buys you a jumper for Christmas, or you just happen to have known someone for a long time and they buy you a case of wine to thank you or something, you might be okay. But it's really just a question of and also making sure that you actually disclose what has happened, that you've had this or you've had that. And obviously the larger it is, I suppose, the worse it's going to look. So perception matters. Be careful, be vigilant, and document anything. But as I keep saying, it's this acting in the best interest of the company, undivided loyalty, acting in good faith. These are the things which basically you have to have at the forefront when dealing with any benefits that you get. Right. Thank you.
Thank you. So you'll be pleased to hear that we are now on the last of the core duties. So turning to sections 177 and 182 of the Companies Act, which is the duty to declare interest in transactions. So specifically here, we're talking about personal interests which are relevant to the transactions the company is entering or considering. So similar to the duty to avoid a conflict, this is also about transparency. So making sure that the board is fully aware of any personal interests a director may have in company dealings. So there are two key points in time when disclosure is required. First, under section 177, a director must declare their interests before a proposed transaction is entered. So this is forward-looking. The board needs to know about the interests before making the decision. Second, under section 182, if the interest relates to an existing transaction and that hasn't already been declared, that director must disclose their interest as soon as reasonably practicable afterwards. So in terms of what needs to be declared, directors must be clear about both the nature of their interest and the extent of it. So this includes not just direct interests, but also indirect interests. For example, where a connected person or another business that the director is involved in stands to benefit. So there are a few ways this declaration can be made. The most common is at a board meeting, or they can do this by written notice to the other directors, or even by a general standing notice where this is permitted. So for example, by declaring an ongoing interest in a particular company. So in practice, this duty works alongside the conflict of interest rules. It is distinct. So it's specifically about transactions with the company. So transparency is going to protect both the director and the company, and by declaring interests early, directors are going to be reducing the legal risk, ensure proper decision making, and they're going to be protecting the integrity of those board decisions. Thank you. Over to you, Graham.
Right, so some real world examples. Most of these are quite old, but they're sort of the clearer ones, really. So duty of to exercise care and skill, Dejan of London Limited. Here, a director basically didn't read an insurance document. One of the questions from the broker was, have you ever been a director of a company that has gone into insolvency? Mr. Dejan had been a director of a previous company that had gone into insolvency, but didn't read the form and effectively allowed the box that ticked that he hadn't been, as it were, to go forward. There was an issue involving insurance, and lo and behold, the insurance company turned around and said, well, it's void because you didn't give us full disclosure. The liquidator challenged this, took it to court, and said effectively, had there been insurance, the company wouldn't be in the situation it was, and the creditors would have been paid, and effectively asked that Mr. Dejan should pick up the bill. Now, interestingly, in this case, the court did award that Mr. Dejan should pay a sum of money, and effectively he was owed dividends. He was a creditor, as it were. He was owed dividends as a shareholder from the company, and the judge sort of did a bit more of a fudge, saying, I think you should pay about 102,000, but that should take into account your dividends, etc. But the key thing in Dejan was that Dejan was a 99% shareholder of the company, and his wife was a 1% shareholder, and they claimed that they'd ratified the error, and so therefore everything had been disclosed. The judge wasn't particularly impressed, as I say, did knock this 102,000 off Dejan's bank balance. But again, it's an indication of how, you know, what can be so innocently done can come back and bite you if a liquidator, you know, wants to show the teeth. Conflict of interest, this is an interesting one. Regal, which again, yes, it is a cinema. Regal Hastings versus Gulliver. So Regal Hastings was a one cinema business, and it wanted to expand because it saw opportunities in other areas around the East Sussex district. It went to buy 2 new cinemas. Basically, it had to, for reasons, business reasons, set up as a new co, as it were, a sort of Regal 2. The deal with the cinema, the other two cinema, the owner of the other two cinemas was going ahead, but the landlord who actually owned the buildings was unimpressed by the new co and effectively said, I'll give you two options. You either give me a personal guarantee or you put more capital into the business. No one wanted to give a personal guarantee, so they each stumped up, I say each, not all of the shareholders, but some of the shareholders stumped up monies to effectively put into the Regal new co, and the deal went through. So far, so good. Later, a few years down the line, Regal 2 was sold. It had obviously been obviously it had been a very profitable business because it was sold for a higher sum of money. And in this, the original Regal Hastings effectively sued to say that there was a conflict of interest, that effectively the profit that had been made, as it were, on the share increase was almost a secret profit. It was a fiduciary duty breach because it was a conflict of interest, that they had benefited and that they only found themselves in that situation because they'd been part of Regal Hastings in the first place. And again, they were asked or told by the judge to account for those profits. Now, there's kind of a theme, again, I'll just pause here running, isn't there? Dejan was pursued by the liquidator after the company had gone into receivership. Regal, as it were, was caused because there was a conflict between, as it were, old co and new co in terms of the deal that happened. And so again, at the time of all of this, it all looked absolutely fine. There was no problem. So it is important that, with going back to with hindsight, that records are kept. Anyway, moving on. Benefits from third parties. Now, this is an interesting one because this is the case that is always quoted in regard to secret commissions and secret profits, but it doesn't actually strictly pertain to directors, but it is always the case that's used. So broadly, FHR European Ventures were looking to diversify, get bigger, and to buy other businesses. Cedar Capital were effectively what it says on the tin. They were almost a broker. They would find appropriate targets for entities that wanted to expand and try and do a deal. What Capital didn't disclose is that they, as it were, played both ways. They would sign up to an agreement with FHR European Ventures to say, yes, I'll find you suitable targets. But then they would always also advertise with any potential target companies and say, would you like me to find a buyer for your business? In this situation, Capital put, as it were, the buyer and the seller in touch, charged them both, as it were, a commission. And FHR were unaware that they had, as it were, done this double whammy, that they got money in from the seller as well as from themselves, the buyer. And in this situation, it was deemed to be an undisclosed benefit that was linked to the office, going back to the fiduciary situation, and that they were prohibited from making that profit and they had to account for it. So again, not strictly director, but it is the leading case on that. Declaration of interest. I mean, this is again another interesting one and shows its age because I don't think there is an independent Aberdeen Railway anymore. But Aberdeen Railway had a director, Mr. Blakey. Mr. Blakey also had a side hustle making iron furniture with his brothers, the Blakeys. So he was a director of Aberdeen Railway, but he was also a partner in Blakey Brothers. Aberdeen Railway agreed to buy a large number of shares from Blakey Brothers, and the deal was done. As Aberdeen Railway went on, they started to have difficulties in paying Blakey Brothers, and so looked for, as it were, alternative reasons to challenge the contract. And they fastened on the fact that Mr. Blakey was a director of Aberdeen and hadn't declared his interest in Blakey Brothers. Now, you'll appreciate the slight irony in this, in that his name is Blakey, he's a director, and you're entering into a contract with Blakey Brothers. But again, because it had fallen out, this came up, and the court basically agreed. It said it wasn't made explicit that this was the conflict that it potentially did become, and because of that, it set aside the contract. So basically, the contract was null and void, and the parties were to be put in the position they would have been in before. So again, the reason I sort of refer to these is primarily because we are looking at scenarios where things were good and then turned bad, and the badness, as it were, led to the scrutiny. Anyway.
Thanks, Graham. Yeah, so that it's worth now looking at how a court is going to approach the question of whether a director has breached their duties. So the key starting point here is that the courts focus on the decision-making process, not just the outcome, which I hope we've kind of been making clear throughout this. But a decision that turns out badly does not automatically mean that there has been a breach. What matters is how that decision was reached. So the courts apply a combination of objective and subjective tests. Some duties are judged against what the reasonable director would have done in the circumstances. Others will also take into account the particular director's own knowledge, skill and experience, which Graham has already gone into detail on. But anyway, expectations can be more higher for more experienced or specialist directors. Another key question is good faith and purpose. So the court will ask, did the director act honestly and in good faith? And were any powers used for a proper purpose? When assessing this, the court is going to look closely at the evidence available. So this is going to include things like the board minutes, whether relevant factors were considered properly. So this may include the section 172 factors that we went through earlier, whether professional advice was sought and followed, and how any conflicts of interest were disclosed and managed. So importantly, the courts are really reluctant to second guess commercial decisions. They do recognise that directors are there to make business judgments and often in uncertain conditions. However, there will be a difference where the decision-making process was rational and directors can show that they understood and applied their duties properly. Therefore, strong governance, clear records and early disclosure are a director's best protection. So if the process is sound and well documented, directors are in a much stronger position, even if the outcome is not quite as what was hoped for.
Thank you, Ellie. So this slide is really in here for you all to sort of look at if you need to as an aid memoir later on. I think we've touched on most of it. So what are the consequences of directors' breaches? Well, civil consequences if a liquidator were to sue you or there was a derivative action by the shareholders, as it were, against you. Directors may be required to compensate the company for any losses, account for any profits, return any property or benefits that they've obtained improperly. They're personally liable. I think, just to be clear, obviously they're a director of an incorporated company that has limited liability, but they are personally liable for their own breaches, as it were. So we've just set that out to make it absolutely clear. There is, and again, this would be a separate talk, but the Directors' Disqualification Act, that obviously means that a director can be barred from being a director for up to 15 years. Usually, you'll be pleased to hear they're only taken in very extreme cases. And again, often the breaches or the director's behaviour is, and again, I've never quite got to the bottom of how, but I think there is almost like a list somewhere, like Santa's naughty list, where if there are continuing breaches and a continuing series of, poor trading, insolvent companies, issues, I think that always seems to make its way to what is called the Directors' Disqualification Unit, who would prosecute this. So often, first offence, unless it is very serious, may just go unnoticed. But if there are 2 or 3, sometimes it might be, a much later offence. But there is reference, as it were. So it all counts together. Yes. So just as I say, hopefully that won't be you, but 15 years is the maximum. We've talked about really insolvency and how important that is. And I think it's important primarily because, going back to the naughty list, on any insolvency, there is a form that is completed by the liquidator at the end of the process. And there's a little box that really says something along the lines of, was there anything about this liquidation that you thought was naughty? And the liquidator, again, 9 times out of 10 would just say no, or business issues, or no problem. But if they find something that is more worrying, they will complete that box and lodge it. And often the disqualification will come or be started as a result of that liquidation, unless we are looking at sort of something which is more of an offence in itself, such as polluting a river, or something more sort of newsworthy. So Going back to insolvency, obviously what the reason I'm mentioning it in that context is often the starting point and the trigger, but we've had regard to creditor duty, we've talked about wrongful trading, and we've talked about a liquidator being able to come after you personally for misfeasance. So again, that coupled with the creditor duty and heightened sort of a heightened level of scrutiny, mean that really insolvency is something to be treated with the greatest of respect. Finally, reputation and practical impact. As you know, we're hearing with Mr. Dejan's case, there are a number of financial forms that often will ask, have you been a director of an insolvent company? So it will affect you in terms of your credit rating, etc., potentially. And again, if you want another job somewhere, etc., obviously it can have bigger impacts going forward. But that's the overview. Back to you, Ellie.
Thank you. So looking now at the tips to avoid or reduce exposure to breaches. So the first point is understanding the duties themselves. The directors should have a working knowledge of the statutory duties under sections 171 to 177 of the Companies Act. Now, that does sound really obvious, but in practice, it is often overlooked and can be forgotten. So attending sessions like this one today can act as a great refresher. The second area is following a robust decision-making process. So directors should be ensuring that they are properly informed when making the decision, so that they've got all the right information available to them when they make those decisions, and that those decisions are properly reasoned with clear justification. So they should consider relevant factors such as the section 172 factors and make sure that those are recorded in their board minutes. This ties back to what courts look for. They're looking for process over outcome. So even if a decision turns out badly, a strong, well-documented process is going to provide some protection. The third area is managing conflicts transparently. So directors should make sure that they're declaring their interests early, fully and clearly, and obtain board authorization where the articles allow for the conflict. And be prepared to step back from decisions where a particular director is conflicted. So if you've got a personal interest, sometimes the safest course is simply just do not participate at all in that decision, and then you know that you're safe. That doesn't mean that you shouldn't declare it, still declare it, but just then take a step back. Thanks, Graham.
Thank you. Right. So again, reducing exposure tips 2. We've touched on some of this and we're bringing it all together now. Seek and use professional advice. So that's not a out and out plug to use our services, but obviously if you're unsure, that will dilute, as it were, your exposure, be that legal, financial or other specialist advice. Again, make sure you document that it's considered, the advice, and that it's understood, and record this in any board papers. Again, the times you'll see that there has been advice actually warning of what happens and it's not followed. I know that's not you guys, but it is a factor. I've said this: stay engaged, read board papers carefully, ask questions, challenge assumptions, attend meetings, minute everything. I say this just simply because usually directors sort of as well, a bit like cabinet responsibility, if a decision is made, it's just made by the company, and so it's made by the board. And so again, if it's an issue, all of the directors are effectively tarred by that brush. But when you look at the minutes, if for example it's one particularly loud director or there's a faction, the fact that you have kind of voiced a concern or whatever may be something which is taken into account, should any of that ever be used against you later on in a court of law. But do challenge and be active. Again, a lot of this stuff goes through or is unminuted, and there isn't sort of any safeguard. We're scrambling to put stuff together, and there's nothing to help us. And obviously, again, I keep banging on about this, but monitor the financial position. I know it's obvious, but again, it changes if there are any issues, and then it's often the trigger at the end. So again, just be vigilant. Now, key takeaways, and again, it's a bit like I was always said when you give a talk: say what you're going to say it, and then say what you've said. I think this is really, again, a slide for you, just bringing it all together, a summary. Personally liable, duties owed to the company, core duties set out in the Companies Act 2006, summary of the duties which we've gone through, how the court would look at things, consequences of any breaches, and as I say, best protection is to be a Boy Scout or a Girl Guide, play with a straight bat, an open bat, and keep good records. And if you have any doubts or issues, share it at a board meeting, disclose it as Ellie has said, and or take legal advice, but make sure there is a record. So that brings us to the end. Again, thank you so much. If you have any questions, please email us with those and we'll come back to you. As if you want to talk again, discussion, a telephone call, let us know. Sorry, I'm giving a talk. Ellie will be providing a frequently asked questions sheet very shortly. Let us have your feedback, please. We do take it seriously. And then finally, as promised, our contact details. If you need to get hold of us or you have a question, please do not hesitate to pick up the phone or email either one of us, and we will happily have a chat with you and run through things and try and help. Thanks very much.
There are a couple of questions in the chat box. I don't know whether we want to deal with them now.
Okay, let's have a look. Sorry, I'll see if I can.
No, that's fine. Sorry, everyone. We're still getting used to this technology.
Right. Can you read them out to me, Ellie? So I'm struggling to find mine.
The first question is, what is the difference between statutory and non-statutory? I don't know whether it's worth going back to our first slide.
The one on the setup. I mean, the answer is really there isn't any difference. It's just more to give you, for the purpose of the talk, the source of how everything fits together, really. They are both, as it were, dangerous. It must be abided by. But the main common law duty really is the creditor duty. The remaining aspects really are more around refining the statutory duties. I hope that answers the question. What's the other one?
The second question is, if I'd worked for a previous company who can provide services to a new company the director is now in, would it be a conflict of interest for that director to recommend using the previous company?
I suppose it's really whether that creates some form of conflict. There are a couple of duties. Sorry, Ellie. Sorry if I missed.
I think that it's just important to make it clear and make sure that everyone's aware of your previous role within that previous company. And like I said earlier, if that means stepping out and not being party to those decisions, you might want to just make the suggestion, say, look, I know that this company can do this because I've obviously worked for them before, but then leave that decision with them. You don't necessarily need to get involved any further beyond that, and then make sure that that's well documented, that you've done that, and that's a conversation which has been had. Hopefully that helps.
Sorry, what's the, is there another one, Annie?
No, I think.
So I've got one. How far do these duties apply to employees with director in their job title, or are the duties solely for statutory directors? That is, I think there's a lot around. That's a very wide question, I think is what I'm trying to say. There is a lot around, for example, holding yourself out as a shadow director and things along those lines, where these duties would still bite. So to answer the question, yes, technically they would be for those that are appointed and at Companies House as directors. They are the directors. But if you are holding yourself out as a director, it's very hard for me to say yes or no. There's a sort of an extent there, a scale, but I think I would just be careful.
Yeah, I think the agency principles make the whole thing quite complicated, but we can touch on this in the frequently asked question sheet, which will be circulated next week. So we can provide a bit more information on that, ready for you to review in your own time. Hopefully that's answered everyone's questions now.
Good. Right. Thank you again, and we'll be in touch, as I say, and I hope you have a good remainder of your day. Thank you.
Thank you.